This is an application and appeal in the matter of Weavabel Group Limited and Lance and Christie.
Yes, Mr Hitchens.
My lords, just to start with housekeeping, I hope you have a core authorities bundle.
2.
Well, my lord, I'm sorry about that. We filed the agreed authorities bundle, and my learned friend and I had a conversation and formed the view that we ought to try and narrow the number of authorities we put before the court. So there should be a shorter authorities bundle, which is the one that my learned friend and I will be working from. And that one runs to 23 tabs.
Well, we'll just have to work on the ones that we've got.
It is 23 tabs,
Yeah.
but it's 713 pages, so it doesn't fit within one file, which is why we've all got it in 2, I think.
I'm grateful, my lord. I apologise for that. My lords, then I hope a core hearing bundle and a supplementary hearing bundle as well.
And again, the supplementary bundle is divided into 2 for the same reason.
I understand. And then skeleton items from both myself and my learned friend. My lords, I appear on behalf of the appellants in this matter. My learned friend, Mr Reed of King's Counsel, appears on behalf of the respondent.
You can take it that we've read all the papers, that we have a keen appreciation of the issues. So unless we indicate otherwise, you can take all the background stuff as read.
That's very helpful. I'm grateful, my lord. My lord, there's one matter that my learned friend and I weren't entirely clear on, which is what application is listed before your lordships. We noticed that the listing is for both the hearing of the appeal and an application. So far as we're aware, there isn't an outstanding application before the court.
Well, let's operate on that basis.
I'm grateful. My lord, before I get into the substance of my submissions, can I just be clear what this appeal is and is not about? This appeal does not concern the lawfulness, the appropriateness, or in general terms, the enforceability of the undertaking given by my client on the 15th November 2023 to His Honour Judge Gosnell. It forms no part of my case that that undertaking should be set aside or was unlawful. What I say is that there were 2 separate and distinct Article 10 interferences. There's the undertaking, which I make no submissions on whatsoever, and separately and distinctly, there's an order for committal, which arises out of things that my client has said in the course of his exercise of his freedom of expression. And I say that that is a separate and distinct act of the state, a separate interference, and therefore it required a separate and distinct proportionality assessment through the framework of Article 10. And can I just show your lordships the way this was put below, just so it's clear how this was presented before Mr Justice Cotter, and ask you please turn up page 203 of the supplemental hearing bundle, the transcript from trial.
Yeah.
It's internal page 139, so it's the top right-hand square, and it's lines 1 to 10. Your lordships will see that the point was made that it's a distinct and separate interference, i.e. the committal order, and that the focus, in public law terms and in the context of Article 10, is the interference with Article 10 arising from an order for committal. So that is the focus, my lords, of ground 1. And I say that because both in the judgment, and we'll go to it, but also respectfully in the respondent's submissions, there's a focus on the proportionality, the lawfulness of the undertaking. And I say that wasn't the proper focus for trial, and it's not the proper focus for the appeal either.
Yes, except that if there hadn't been an undertaking, there wouldn't be contempt.
That's of course, my lord.
So, I mean, the extent to which you are capable of divorcing them may be a matter of debate.
My lord, yes, I accept that. can I give a headline argument to that I then answer to that, forgive me, that I then develop in the course of my submission?
Well, don't let me take you out of your course. I'm just indicating.
I'm grateful.
Yeah.
So my lord, moving on to ground one, there are two aspects to ground one, two separate limbs. The first is that I say respectfully his lordship erred in finding that Article 10 was not engaged at all, and that the principal basis upon which his lordship reached his judgment was to find that there was simply no need to conduct a proportionality exercise whatsoever. And I say that that was wrong in law. The second limb of ground one is to the extent that his lordship did carry out a proportionality assessment, I say that the conclusion that his lordship reached was wrong, and respectfully that the reasoning was flawed. So my lord, can we look please just initially on the first limb of ground one? Could we look please at what his lordship said in the judgment? It's page 85 of the court bundle. And when your lordships get there, it's paragraph B on the page. And it's the second half of the paragraph I say is the consequential one. In any event, and in my view, unarguably, in choosing to settle the action and give the undertaking, Mr. Lance Christie formally and unequivocally gave up his right to pursue these arguments. These arguments being arguments concerning Article 10. Mr. Hitchens made very detailed submissions about the effects of the undertaking. And he says that we ignored the effects of Mr. Christie's actions upon others. His lordship says that in giving the undertaking or accepting the undertaking, the respondent to this appeal lost the ability to argue that the Article 8 rights of Mr. Christie's family required protection, and therefore the injunction, as it would have been if the undertaking wasn't given, should be made. And the final aspect of this paragraph, which I say is significant, is the final part. It is simply not open to Mr. Lance Christie to argue that his Article 10 rights are engaged on this committal and that they require it be dismissed. But simply, that ship sailed away when he voluntarily gave the limited undertaking not to make derogatory comments about his family. My lords, I say that is a clear an unequivocal finding by the High Court that my client had no entitlement to rely on Article 10 whatsoever in the course of the committal proceedings. Just pausing there for a moment, in respect to the arguments about Article 8 or the reasoning concerning Article 8, there is no evidence before the court that Article 8 formed any part whatsoever of the respondent's case before His Honour Judge Coulson. And indeed, respectfully, it's difficult to see how Article 8 could have formed part of the case in circumstances where what was being litigated was a commercial settlement or employment settlement agreement which protected the company and the officers and the directors of the company. It was not a settlement agreement intended or agreed to in order to protect the personal reputation or rights or Article 8 rights of any individual.
What other basis would there be for protecting individuals from derogatory comments?
Well, my lord, it's a common. The underlying settlement agreement was effectively in a COT3, a standard settlement agreement in the course of employment disputes. It's an absolutely standard term in those settlement agreements that each party will not make derogatory comments about the other. When it was made, my client was the managing director of Weavabel Group. The only reason he was even a party to the settlement...
He had been.
I'm sorry, my lord.
He had been the managing director.
When the settlement, not the undertaking, my lord, when the actual employment settlement agreement was
The
reached,
2017
still managing director.
Yeah.
So it was a standard term in an employment contract that is intended to protect the commercial interests of the company, to prevent it from being disparaged. And it's a term which is intended to protect the person who had brought the employment proceedings or threatening employment proceedings so that their future employment prospects aren't damaged. This was not a settlement agreement, for example, in the course of defamation proceedings or the tort of misuse of private information, where the purpose of those proceedings and the focus of those proceedings are to protect reputations. And I say the commercial context is significant when your lordships come to consider the issue of proportionality. My lords, can I just ask you please just to also look at page 4 bundle 93, please.
Yeah.
And this is paragraph 87 of the judgment, second half. However, as already set out, there is no scope for Article 10 argument given the compromise reached. So the basis of his lordship's judgment, primarily, and we'll come to the assessment of proportionality in due course, but the primary basis of his lordship's judgment is Article 10 is of no application whatsoever.
Mm-hmm.
My lord, if we turn to the authorities bundle now, I'll go through the reasons why I say respectfully that was wrong. And we'll start with the statute. So tab 3, please, of the authorities bundle. Should be section 7 of human rights act.
Tab 3, yeah.
Yes, my lord. Section 7, I hope, is what's in
Yeah.
front of you. I'm grateful. The person who claims public authority has acted or proposes to act in a way which is unlawful by reason of section 6.1, so that's the duty under, of course, your lordships will be familiar, the duty for public authorities, including the court, to act compatibly with convention rights, may rely on the convention rights or rights concerned in any legal proceedings if you be the victim of that unlawful act. Now, what was the argument? What was the claim of victimhood under the convention in this case? The claim of victimhood was not that the undertaking was unlawful, not that the undertaking was a breach of convention rights, it's that the committal on the very specific facts of this case and the type of speech which was engaged, that the committal would be an unlawful interference. Now, the reason I highlight this is my learned friend says in his skeleton, well, he had the opportunity to rely on Article 10 rights. He could have done that at the undertaking stage. Section 7 is therefore vindicated. He's had his Section 7 rights, and he's not entitled to rely on them again at the point of committal. But, my lords, respectfully, that isn't an answer to my client's right under Article 7.1b, Section 7.1b, because that doesn't allow him to rely on the convention in respect of the act, which he says would amount to an interference with his convention rights, because the act was the committal order. And then, my lords, the next bit of statute is at tab 4, section 12 of the Human Rights Act.
Mm-hmm.
And the point is that the focus, just as the focus in section 6 is on section 7, forgive me, is on the actual act that it says to be unlawful, the focus in section 12 is the relief. So the court must, when it's considering granting relief, which might affect the right to free expression, section 12.4 enjoins the court, requires the court to have particular regard to the importance of the convention right of freedom of expressions, and then goes on to other provisions. So there's Parliament, I say, has instructed the courts that whenever the court is granting relief or contemplating granting relief which affects or has a bearing on the right to free expression, it must consider the importance of that right, and I say by extension that must do a proportionality assessment.
I suppose a case in which the Article 10 right had been expressly waived,
Yes.
and you then claim that you're the victim of an interference at the enforcement stage.
Yes.
Of course you can raise it And of course the court can consider it, but the court will conclude, if the waiver has been effected in a way that complies with the criteria laid down in the authorities, the court will conclude, well, having had particular regard to it, we conclude that it's been exhausted.
Well, my lord, I think that's best answered by going to my onus, which I will in a minute, but can I give my headline answer to that, which is, you cannot waive, I say you cannot waive your Article 10 rights. I say that when you get to the
You can't waive your Article 10 rights.
I say
And you're going to show us authority for
I'm
that.
going to go to it in one moment, my lord, yes. Absolutely, they're the next two authorities I'm going to. But I accept, my lord, absolutely I accept that when you come to the balancing exercise on the enforcement stage, a very powerful, a very compelling feature of the proportionality exercise the court must undertake will of course be the principle of finality, and will of course be the terms of the agreement which has been reached. And I accept that often that may be a decisive feature of the balancing exercise, but it's nonetheless incumbent on the court, I say, to conduct an assessment, to consider all of the circumstances in the case, and consider whether exceptionally on the facts of this case, it would be incompatible with Article 10 to grant the relief which is being sought. In this case, an order for committal. And my lords, can I just ask you to turn up page 451 of the authorities bundle? This is the judgment of Dame Victoria Sharp in my own S.
Yeah.
And this case arises out of facts which are essentially a stage earlier than our case. So this is a case where...
This is a completely different case because it's not a case of contempt of court.
My lord, no, it's not a case of contempt of court.
So you'll show us, after we've looked at this case, you'll show us the authority that says that in a committal for a contempt of court, the judge was wrong in law. So we're starting with why, if let's say the settlement of July 2017,
Yes.
water long under the bridge, but at that point you say, well, look at 65.
Well, my lord,
Is that right? That's what we look.
I say look at 65.
Yeah.
And I say when you read, I say when you read 65 to 67,
Yeah.
It's clear, I say, as a matter of domestic law and also under Strasbourg jurisprudence, you cannot waive Article 10. Now, it doesn't, for me, in my respectful submission, the distinction of whether you're said to have waived it through a settlement agreement or you're said to have waived it through an undertaking doesn't affect the underlying principle, which is Article 10 continues to be engaged.
So the distinction between a private law settlement
Yes.
and a contempt of court, you say is irrelevant.
I say solely on the issue of waiver. It's
Not
not
talking about waiver. You say it's irrelevant for Article 10 purposes.
No, of course I don't say that, my lord. No, I don't say that.
So what do you say? Because you've drawn our attention
Yes.
to a case in which, in fact, the private law agreement was sufficient to defeat the Article 10 claim.
Yes.
But on the principle, you say, well, the court has to consider it, even if the Balancing Act may well come out in favour of the party objecting. But where do we get anything in this about, in this case, about an undertaken given to the court and breached? A contempt of court. We don't, do we?
My lord, what I say, the only thing I say we get from this case is that one cannot waive your Article 10 rights.
Well, I'm puzzled about, you will have to show me that, because I'm looking at the middle of paragraph 66, where Lady Justice Sharp said that the parties referred to no case where waiver has been specifically considered in relation to Article 10, or where it's been said that wherever Article 10 is engaged, the right to freedom of expression cannot be waived.
Well,
So that rather seems to be against you,
well,
so far as the jurisprudence cited in that case was concerned.
well, so far as the Strasbourg authorities, my lord, because I haven't been able to identify a case from the Strasbourg courts either. What I rely on is primarily paragraph 67, where her ladyship relied primarily on section 12. Essentially,
Yes, well, that's very fair, if I may say so. But can I ask you this question? Because the conclusion in the last sentence
yes,
might be said to be this, and I'm interested in your submission. The conclusion might be said to be, yes, you can waive your Article 10 rights, but the court has a policing role. That is to say, to ensure that the waiver is one that passes muster.
my lord, my submission is that when one reads particularly the final part of paragraph 67 of my onus, starting with however the fact the parties have entered into agreement voluntarily, I say what your lordships can get from this case is that whatever the private agreement between the parties and whatever undertaking or promise given by a party, precisely as my Lord Justice Arnold has said, that the court retains a policing jurisdiction and must be satisfied that the relief which it is being asked to give is proportionate and lawful. And I say,
well, no, it's the bargain. Look at the last sentence. It's such a bargain was disproportionate. So what the focus there is upon the bargain by which the Article 10 right was given up.
yes. But my lord, when this is predicated on section 12 of the US Act, when you read section 12, what it says is the focus is the relief that is being sought. The court has to have regard to the importance of the right to freedom of expression. So the focus, I say, the proper focus for Mr Justice Cotter in this case is whether the relief of granting a committal order was proportionate and lawful within the sense of Article 10. And I absolutely accept what her ladyship does say in my onus very clearly, is that, of course, the fact that it is a voluntarily entered agreement and the principle of finality and all the other pressing public interest issues surrounding that are weighty and significant considerations when you're conducting that assessment.
So the proposition really is that section 12, subsection 1 and 4 apply at the stage when the court is accepting the undertakings. I think this is taking your argument a little further. But they also apply at the later stage when the court is asked to give relief to give effect to those undertakings by way of committal.
My lord, yes, and the reason I say that is partly my onus, but I accept the observations of the court in respect of what's said in that. But also, it's the focus of the legislation, because section 7.1, the focus of section 7.1 is the act which is said to give rise to an unlawful interference. In this case, the act which is said to give rise to an unlawful interference is the committal order, it's not the undertaking. And also, section 12, the focus is on any relief, so it's the proportionality and the lawfulness of the relief granted, which in this case is a committal order. And that's why I say the final authority, just to take your lordships to, if I may, it's page 71, it's the case of Handyside. And it's the final paragraph when your lordships get that. And
Sorry, it's page.
It's page 71 of the core authorities. paragraph of the final, forgive me, it's final sentence of the final paragraph. This means, amongst other things, that every formality, condition, restriction, or penalty.
I beg your pardon, I'm in the wrong place. Could you repeat the
I'm
reference?
so sorry, it's page 71, my lord, of the Core Authority Bundle. It's posted handy side.
Yeah,
And it's the final sentence of the final paragraph.
yeah, thank you.
And the point that I'm making is that the Strasbourg courts say that every formality, condition, restriction, or penalty imposed in the sphere, i.e. the sphere of freedom of expression, must be proportionate to the legitimate aim pursued. Now, what was the restriction in this case? It was the undertaking. But his lordship was absolutely right. That ship has sailed. I'm not entitled to make any submissions in respect to the undertaking. But the penalty was an order for committal. And what the Strasbourg court is saying is that you have to be satisfied that that penalty is proportionate to the legitimate aim relied upon. And that's why I say it was incumbent on his lordship to satisfy himself, not that the undertaking was properly given or was lawful, but rather the order for committal that his lordship was imposing was proportionate and was pursuant to legitimate aim. So that's why I say respectfully that the primary avenue of his lordship's reasoning in respect to the applicability of Article 10 was flawed. And respectfully as well.
I appreciate why you say that there's a distinction between the penalty imposed for contempt of court and the undertaking, which is the foundation. But does it not lead to this conclusion that is tantamount to saying that the undertaking is unenforceable?
My lord, no, because my argument on proportionality hinges entirely on the particular facts of this committal. Now, to draw an analogy, Ziegler in the Supreme Court, Parliament passes the Public Order Act. There's no suggestion that that act is unenforceable, but on the specific facts of Ziegler, well-known authority, the Supreme Court ultimately found that it would be disproportionate to impose a criminal conviction. Now, nobody is saying that that act is inherently unenforceable. They're saying in the specific facts of that prosecution, it's a disproportionate interference with Article 10 and 11. And the same is here. I'm not saying that undertaking is unenforceable. All I'm saying is that his lordship needed to consider the very specific facts of this committal and be satisfied that it was proportionate within an Article 10 context. And
Well, you say, just want to pause you there. It was proportionate.
it's a committal order.
In other words, the sanction.
The sanction, well, the making of a committal order, yes.
Yeah.
Yes.
So I think there are two different strands to what you're saying about this. One, if I can put them in reverse order, is the penalty, in this case, committal for 14 days suspended,
Yes.
has to be proportionate to
Yes.
what's happened, and the legitimate aim or aims, which presumably are the protection of the rights of others and maintaining the authority of the judiciary, in Article 10(2) terms.
Yes.
To that extent, it may be that there's not a lot of pushback. But the other limb seems to be that the court is obliged to consider whether to enforce the bargain. And that's perhaps more difficult.
If that's appears to be a limb of my argument, my lord, it's because I haven't expressed myself very well. I don't say that the court has to look at the undertaking, say the undertaking is disproportionate, and therefore I'm not prepared to make any committal on the basis.
No,
of
I understand that, but there's a second question. Without impugning the bargain, the question would be, well, okay, this is the bargain. This is what was agreed. It's legally valid, but is it appropriate to do anything to enforce it? Because, as you have argued, as I understand it, it has a collateral effect on the freedom of your client to criticise the conduct of the Plymouth Prep. That's the area that I'm identifying as your second limb.
Yes.
And that's the bit that I perceives to be a bit more difficult, because that was the bargain.
Well, the bargain was not to make derogatory comments about his family.
Yeah.
That was the bargain. Now, there are... I suppose there are two answers to your Lordship's question. The first is, it is already a requirement that a contempt application must be proportionate. Not in a public law sense, but must be a proportionate use of the court's time and a reasonable thing to embark on.
Well, that's true whether Article 10 is engaged or not.
This is precisely my point, my lord. So I'm saying that the notion that simply saying you have to be satisfied in a case where convention rights are engaged, that it's proportionate in a public law sense, in the meaning of Section 6, isn't, as Mr Justice Cotter said, a hole in the ship, as it were, that's going to sink the whole enforceability of the orders. It's a different aspect of proportionality in circumstances where the court is already required to consider the proportionality of an application for committal. And it's never been suggested that simply the court simply looking at, well, is this a proportionate use of the court's time? Is it reasonable? Is it in accordance with the overriding objective? Somehow undermines the enforceability of orders in generality. Because one of the things, of course, you'd consider when you're considering the proportionality from an overriding objective point of view is it is important that court orders are abided by. There is a pressing public interest in the...
Well, we're not in that territory, though, are we here? That's not an issue that's been raised.
No, but I'm drawing an analogy, my lord. Because
I understand that.
What's said by Mr Justice Cotter is, well, as soon as we allow issues of proportionality to enter into the fray, then the whole regime grinds to a halt and falls apart. Well, respectfully, that's not the case. The court's already considered the issue of proportionality in a different context, and there's no suggestion that's caused any significant issues.
On this point, which is obviously your main point, is there any authority you want to show us that you rely on in a committal case, a contempt of court case?
Well, there's no authority I've been able to find where the court has considered this issue.
No. If you're right, this would be very new law.
My lord, in a sense, respectfully, it's not new law. It's well established.
Well, it would be, because it would be saying, well, don't worry, if you've promised somebody something and then you've subsequently promised the court something, if you can rely on your Article 10 rights, you can buy off both the cost of the settlement with the private law firm and not worry about the contempt of court because of your Article 10 rights.
It's not a golden bullet, my lord. It's not a get out of jail free card.
Well, it is. There's then the question of on your case would then be the question of proportionality. But as a matter of principle, it is, because you say that's wrong in law, not to have regard to Article 10 in these circumstances. So it is a golden bullet, Mr Hitchins, subject to proportionality.
But the starting point, my lord, on my case, the starting point is what Her Ladyship said in my own essay.
You know, I understand that.
So
and we have your submissions. I'm just exploring the consequences of them, which is why I asked you if there was any authority which dealt with this in the context, the specific context of contempt of court. And I'm not aware of one in your submissions.
My lord, there isn't one. I can take it to you.
Could I come back to Lord Justice Warby's question? Because he was suggesting there were two strands to your argument, and you repudiated that suggestion. And I'm trying to understand where analytically that takes one to, because you accept that the undertaking is enforceable, and you accept that it's not the court's function to consider whether or not to enforce that bargain. And therefore, I think, and please correct me if I'm misunderstanding your argument bites only at the stage of sanction. So up until the conclusion of the findings on liability, it doesn't bite. It only bites, I think, when the court imposes a sanction. Is that right?
But Precisely right, my lord. It bites at the point where the court is deciding whether to make a committal order. And by committal order, I of course mean the definition is clear, an order which imposes a
Yeah, so
custody
it's not the finding of breach, it's the penalty, the sanction. That's when the
interference, my
argument
lord.
bites.
Yes, if the court had said a judgment, findings clearly breached his orders, but I've conducted a proportionality assessment and I find on the very specific facts, exceptionally, it's not appropriate to impose a custodial sentence, then I could, of course, my client could have no complaint.
Well, I can understand that. My follow-up question is that really the argument that you were advancing before Mr Justice Cotter? Because he appears to have understood the argument to be a different one. I'm looking at paragraph 34b of his judgment, which is page 76 of the Court Bundle, where he's reciting your argument. And he identifies 4 limbs to it. And this is his summary, so he may have been wrong, you may say he's wrong. But B is, he says you were arguing that a finding of contempt would be incompatible with Articles 8 and 10 of the Convention.
I suspect that's come from me not expressing myself well, my lord. I took you, when I opened, to what I said in oral submissions, where I said an order of committal would be the interference that I was focusing upon.
Well, that may explain why you and me are at odds.
Well,
Why you're complaining about a part of his judgment, because it looks as though that part of the judgment may have been addressing what he took to be
yes.
your argument that he couldn't make a finding of contempt
Well,
because of Article 10, whereas your argument actually was and is that he can, but that the Article 10 point kicks in when it comes to sanction.
Yeah. So can I just pursue this distinction, because there's no reason why you or anybody else in court should be aware of it, but there's been a recent decision of this court in a case called Merck and Merck. And the background is trademarks, but that's by the by. The principal issue in this court was whether a party that benefited from a court order and contended that the opposing party was in breach of that court order could ask the court for a declaration that the opposing party was in breach, rather than moving for committal. And the answer given by this court was yes. If you're not seeking to impose a sanction, then it's perfectly appropriate to use the remedy of declaratory relief. Now, am I right in understanding that you would accept that it would have been open for the respondent in our case to have applied for and obtained a declaration that your client was in breach of his undertaking?
Going back to the language pandy side, I don't think it could be sensibly argued that a declaration would be a penalty, a restriction, or a formality. So in those circumstances, doing my best to answer my lord's question on the hoof, I don't think it would be open to my client to say, or in my submission it wouldn't be open to my client to say, well, it'd be a violation of Article 10 for you to make a declaration. Did that answer my lord's question?
Yes, it does. No, that's a very straight answer to a question you had no reason to expect.
Let's just turn my back on. My lord, I'm grateful. So that's my case on the need for a proportionality assessment. Can I make one point in answer to my Lord Justice Coulson's question about the novelty of this approach? In my submission, this is a straightforward application of long-standing principles. The court is a public body within the meaning of Section 6. There's no question in my submission that a finding for committal in these circumstances can sensibly be described as an interference with Article 10. it's a penalty imposed in response to the exercise of freedom of expression. And before a public body takes a step which amounts to interference, it has to satisfy itself, because Parliament's told it to under Section 6.1 of the Human Rights Act, that that interference is lawful and proportionate.
But you don't need Article 10 in a contempt case for the judge who finds contempt, when looking at the question of sanctions, for the judge to know that the sanction has to be proportionate.
Well, there's
That's the whole purpose of sanctions in a contempt case. That's why they're so difficult, because there are so many factors in play. But setting aside Article 10, every judge who's ever imposed sanctions for committal, sorry, on a committal for contempt, is aware that the result must be proportionate.
well, the proportionate in a general sense, yes, of course, my lord.
Well, proportionate, yeah. I mean, it could, in all the circumstances of the case.
My lord, this is why I think the analogy with criminal proceedings is useful, because of course your lordships will be familiar with the Zyger case. It's a very significant case, and it wasn't argued in that case, well, every judge will always make a proportionate sentence in any event, so you don't need to rely on Article 10 or Article 11 in a criminal context. And the same applies here. It's not that of course judges apply the totality principle, of course judges strive to achieve a proportionate and fair outcome for any contempt, but the focus here is it proportionate and fair and in accordance with the totality principle, is the specific interference with Article 10, taking in mind all the factors I'm about to address your lordship on and that are specific to Article 10, is that a proportionate and lawful interference? And the focus is different, because it's not just my client's right.
So cutting through that,
Sorry.
if Article 10 adds something, in this case, what would it have added in terms of the sanction?
Well, I say it was disproportionate to make a committal order. By committal order, I mean an order.
Yeah, the 14 days suspended for 1 year.
My lord, I accept this is not an immediate sentence, and it's a lower range of custodial sentences. It's nonetheless a custodial quasi-criminal sanction imposed on my client in consequence of what I will say is the exercise of supreme expression. And all I say is that Mr Justice Cotter had to be satisfied when considering the
No, we understand that. You'll address us on that. I'm sorry to interrupt. I just want to know what the result would have been. No order?
Well, my position is it certainly didn't cross the custody threshold. Oh, can I just have a
But I think where we've got to in response to the questions I was asking you earlier is that actually on this submission, of course, you have other grounds which we will come to, but as far as this particular aspect of your grounds of appeal is concerned, the result is that actually the judge did nothing wrong, down to and including his finding of liability. Where he went wrong on this submission is that he ought to have imposed no sanction. You say.
I say that had he conducted a proportionality exercise, he wouldn't have imposed a committal order. Now there are a range of sanctions prior to a committal order being made. There's the option of a fine. There's the option, I think, of community resolution. There's other alternative options that could have been imposed. Deferred consideration is another one, where you don't pass the sentence there and then, but you don't pass no penalty. You simply adjourn sentencing for a period of time. So there were other sentencing options which were available to his lordship.
Yes.
And the other point is that the reason it's potentially it's potentially relevant to the liability stage, is that one of our submissions that it was disproportionate in a general sense to pursue this allegation. It was in the navigator equity sense, and if his lordship had determined that it was disproportionate in Article 10 sense to make a committal order, that obviously goes to whether the proceedings as a whole are proportionate. So those are what I say the consequences
That
are.
wasn't an argument before Judge Cotter in his paragraph 34.
I think we did mention it, didn't we? We just got the reference. My lord, I'll just try and find the reference if I may.
Okay. So anyway, you say now
It was
work proceedings as a whole disproportionate.
so disproportionate in a navigator equity sense or the Article 10 sense.
Okay. All right. Well, anyway, we have that solution.
So, my lord, that's why I say the headline. Just before I move on to the second limb of ground one, the headline is there was a public law duty to conduct a proportionality assessment. His lordship erred in law by not undertaking or not accepting that that duty arose. Now,
I'm not suggesting that this debars your argument, but just so as we're clear, where we seem to have arrived at is that the argument you're advancing before this court turns out to be a little different from the way it was put to the judge below, because it's plain that the judge below understood that your argument was being put forward as an answer on liability. So that's the stage at which he considered it.
yes.
It wasn't considered again at the stage of sanction, whereas what you have accepted in answer to my questions is that the judge did nothing wrong, down to and including his, from this perspective,
Yes.
there are different perspectives of course, but on this issue he did nothing wrong, down to and including his finding of liability. Where he went wrong was in not considering compliance with Article 10 at the stage of penalty.
My lord, yes, and I should just be, I've just checked the position. The summary, I think it's just right to highlight the summary that my Lord Justice Warby took us to a moment ago, that was lifted from my scans document. So I think it's a mea culpa in respect of the focus.
Yes.
I take your lordships to the
That's right. We're always happy if arguments get refined. It's when they get expanded we can get a bit jittery, but refined is fine.
I'm grateful, my lord. So the answer to your questions is what's subject to appeal is the committal order. That's the only matter which I'm entitled to argue was wrong. And what I say the error of law was that his lordship did not conduct a proportionality assessment before making that committal order. Now I accept it probably could have been put clearer below. But that's the focus. That's what I say was the truth.
So are we moving on to the proportionality?
Yes.
Now?
Yes. Now, your lordships will be closely familiar with the Bank Mellett test. I'm not going to run through it. I just want to highlight that the only limb that was in dispute before his lordship and the only issue before this court is the final limb of the four-stage test, i.e. whether the objective of the measure is sufficient importance to justify the limitation. I'm so sorry. Is the balancing exercise of whether the severity of the measure's effect on the rights of the person to whom it applies against the importance of the objective and the extent to which that measure would contribute to its achievement, the former outweighs the latter. So, i.e. whether the contribution to the entirely legitimate aim of upholding the court's authority outweighs the effect that it will have, that the committal order has on my client's Article 10 rights. I think it's common ground, and if it's helpful to take lordships to the authorities, I will. An assessment of proportionality is not a finding of fact. The question, none of the, and I understand that's common ground between my own friend and I. The sole question for your lordships is the extent to which Mr Justice Cotter did a proportionality assessment. Was that assessment wrong? That's the only hurdle I have to overcome.
Well, if it was wrong,
If it was wrong,
then we'd have to redo it.
then well, the authorities tend to suggest that your lordships are in as good a position as anyone else simply to make a fresh assessment.
So we would have to redo it. So that's only the first part of the
Yes.
exercise. So the first question is if he was wrong, and then the second one is what's the result of a proportionality exercise? And really the arguments meld into one.
Precisely, my lord, yes. Can we look, please, just at what Mr Justice Cotter said on this? So, immediately after concluding, so it's a core bundle 86, please. Immediately after concluding that my client's Article 10 rights weren't engaged at all, we then have the proportionality balancing exercise at paragraph C. Now, my lords, this amounts to one paragraph of what are effectively
But
open
isn't this the problem with where we've got to on the first aspect of your ground one? Because necessarily the judge is considering proportionality, as I would put it, in the abstract here. Because the argument had been raised at the stage of liability, not at the stage of sanction. And therefore what he's considering is the proportionality of enforcement of the undertaking. He's not considering whether a sentence of 14 days suspended for 12 months would be a disproportionate interference with Article 10 rights, because that wasn't the argument.
My lord, yes. I say that in oral arguments, I took your lordships to the exercise at the start, that the focus was the making of...
Yes, but this was during the trial on liability.
I accept, of course I accept that it was...
And you've accepted that it would have been open to the judge to have applied an alternative sanction, which was non-custodial.
Yes. Or purely declaratory, for example, yes.
Or even purely declaratory, absolutely. And don't you have to show, therefore, that the argument was raised for him at the stage of sanction, and he went wrong there? Because at the moment, I don't see that it was. But if I'm in error there, please point me out.
My lord, can we try and find you the reference? I don't have it to hand.
It's in the sentencing note. It's tab 19.
I'm very grateful to my learned friend. It's tab 19 of the supplemental hearing, and in typically fair fashion, my learned friend has pointed out that it's at paragraph 20.
That's where you raise
Tab 19.
Paragraph 20, page 272 of the supplemental hearing bundle.
Okay, so you did take the point, and I'm grateful to be informed on that.
Yes.
And therefore, the next question is, well, what did the judge say about that in his sentencing remarks?
My lord, it's tab 15 of the core bundle, is the remarks of his lordship in sentencing. I say that there wasn't a proper consideration at all of Article 10 or the right to freedom of expression.
But did you actually ask for anything in consequence? Well, paragraph 20 is, if I may say so, incredibly vague.
My lord, the point at which these submissions were made, Mr Justice Cotter had already determined Article 10 had no application.
But that's
whatsoever.
because, as we've now identified, there was a complete mismatch between the submissions he thought you were making and the submissions you're making now. But as we've seen, you raised the point in general terms at paragraph 20. And the point I'm making to you is, well, great, you raised the point, but it's very vague.
Well, my lord,
It's not asking for anything as a result of that point.
Well, my lord, at this stage, at the sentencing stage, we'd have a 3-day trial where I had consistently argued that the making of committal order would be disproportionate, unlawful interference with Article we'd led evidence on the point. His lordship had clearly and explicitly found that Article 10 wasn't engaged at all.
He'd found you were liable for contempt. Your client was
Yes.
liable for contempt of court. It goes back to the question I asked you earlier. What was the effect? What was the effect you wanted of 20? I think not to make a custodial order.
Yes,
You say now.
my principal submission below was that the custody threshold was not met.
Yes,
That was the focus of all of my submissions before his lordship
yes,
at the sanction hearing.
yes. And that this is the last paragraph under the heading of further mitigation.
Yes.
Right, and so therefore, cutting to the chase as I see it at the moment, the criticism therefore you level against the judge is in his sanction judgment, where you say he fell into error because at that stage he was obliged, on your argument, to consider proportionality, and he didn't.
Yes, and I think what I have to accept is the liability judgment. It didn't lead to any order that amounted to an interference with Article 10 immediately. It was just a finding of the tribunal, of the court, that factually the undertakings had been breached. But an effect of that of his lordship's judgment was that he'd made a clear and unequivocal determination that Article 10 wasn't engaged at all in the committal, and necessarily that infected the approach he took when it came to deciding whether or not to make an order for committal.
But you're now on the second aspect of your ground one, and where we've got to is you say he was obliged to consider proportionality of interference with Article 10. He didn't.
Yes.
Assume you're right about all of that. One's still then left with my Lord Justice Coulson's question: what should he have done? And the submission has to be, doesn't it, that any custodial sentence, no matter how slight, given that he ended up only imposing 14 days suspended for 12 months, any custodial sentence was a disproportionate interference with Article 10. And how do you arrive at that conclusion?
Shall I go through it now, my lord? Because
Yes.
I'd have to persuade your lordships that there is exceptional features of this case, because I accept that in the ordinary run of cases, of course, it wouldn't be a disproportionate interference to make a committal order. Can I start with a bit of time just on the legal importance of the right to freedom of expression in our legal system and the role that the courts are meant to play in protecting and upholding it? If we can start at page 682 of the authorities bundle.
Isn't there any of this we can take as read?
Well, shall I say the principles? And if your lordship disagrees, then
Well, your skeleton argument describes freedom of expression as the bedrock of our society.
yes,
Do we really need authorities for all of that?
my lord, fine. I don't think so.
I mean, I think you footnote that stuff. I mean, there are 2 or 3 purple passages in your skeleton argument on the point. If you just, I think it's best if you just give us the headlines.
I'm grateful, and your lordship has already said my principal submission, which is the right to freedom of expression, is the primary right upon which all other rights rest, and which, without the effective rule of law, is not possible. That's what the authorities tell us. That it's an essential foundation for our democratic society, and crucially, that it is a condition for the progress of each individual. A condition for the progress of each individual's self-fulfillment. So there's a dual aspect to the importance of Article 10. One is the societal and democratic imperative of it, and second is that it's a necessary condition for each individual's self-fulfillment. So there's both an individual and a collective importance to the right to freedom of expression. And I highlight that because I say that both are acutely engaged here. The other point I just make is, and this again is not disputed between my learned friend and I, is that in the words of Lord Justice Laws, the courts owe a special responsibility to the public as the constitutional guardian of the freedom of political debate, as they're ultimately the trustees of our democracy's framework. So this is a fundamentally important right that is necessary both for a well-functioning society and for the fulfilment of individuals. And the courts have a special and heightened obligation to protect and uphold that right. And that, in my respectful submission, is entirely consistent with what Lady Justice Sharp said in My Onus when she described a policing jurisdiction on the part of the courts. Now, in terms of the public interest of the speech complained of, all of the communications, I say, that are complained of and impugned,
Sorry, all of the
communications, the videos, the Does Truth Matter document, the emails, so all of the material which gave rise to the committal application,
contempts.
the contempts,
Yes.
my lord, I say were made in the course of my clients complaining about the doctrine of separation within the Plymouth Brethren Christian Church. I say that the evidence which I'll go through establishes that that doctrine of separation has two effects. The first is it ensnares vulnerable people who might otherwise wish to leave the church. And the second is it destroys the lives of vulnerable people who do leave the church. And I say that that doctrine is implemented through people's families, through their friends, through their employers, and it is artificial and unrealistic to suggest that someone can meaningfully talk about the way the doctrine of separation has been inflicted on them without talking about their family, things their family have done at the behest of the church, and the way that that conduct has affected them.
Well, Mr. Hitchens, the difficulty with that is that that flies in the face of all of the litigation in this case. Because that was the submission made to Judge Gosnell.
It was, my lord.
And Judge Gosnell said no. And counsel then appearing for the appellant accepted that it was right to say that they could be differentiated. You don't need to call your son a liar to expose the problems, the perceived problems with the Plymouth Brethren.
My lord, that example, of calling your son a liar, say that, he says he's been my client says he's been prosecuted at the behest of the PBCC, and PBCC witnesses gave false evidence in support of that prosecution. The judge called the evidence of the witnesses disingenuous. It's difficult in my respectful submission to see how he can effectively say the PBCC caused me to be prosecuted in an unmeritorious prosecution, and they gave false evidence against me, without saying my son gave false evidence.
Well, he has agreed not to say that. And he told Judge Cotter, Mr Justice Cotter, that he wouldn't say that again.
I understand, my lord.
And so if you are, the problem with this argument is we're going to be back here 6 months, a year's time, except the sanction won't be 14 days suspended.
Well, my lord, there are two answers to that. The first is, in terms of the general point of, well, this has all been litigated, I accept they're absolutely powerful points in any proportionality exercise.
They're a complete answer. On the principle of finality, they're a complete answer. It was accepted on his behalf in front of Judge Gosnell that they could be separated. In consequence of that, the undertakings were given.
My lord, in terms of, I go as far as to absolutely accept they're compelling and powerful considerations. I say that respectfully, they're not a complete answer, because the court, I say the proper approach to the court in conducting a proportionality balancing exercise is to take account of all of the factors in the case, including the finality principle, but also including the very particular circumstances and facts of this case, and then reach a conclusion on proportionality. I say it's not a case where any individual or singular feature is a complete answer. In terms of we're simply going to be back here point, my lord, the evidence of Mr Christie was focused, as your lordship will have seen, on the relationship between him and his family. He recognises that the speech complained of has damaged the relationship with his family that he desperately wants reconciliation with. So it's not the case, my lord, that we're going to be back here again simply because he maintains that he couldn't have effectively spoken about the doctrine of separation without mentioning his family. You will have seen Mr Justice Cotter accepted his sincerity when he said he wants to draw this to an end and he wants reconciliation. He's not going to commit any breaches. And I don't want any of my submissions to indicate or to suggest that that wasn't sincerely said or that doesn't remain the position, because it does. So, my lord, I say the issue of the doctrine of separation and the issue of the conduct of religious organisations in this country and the effects those religious organisations have on their followers and their communions is a matter of real public interest and importance. And if I could ask your lordships please to turn up.
I don't think that statement is an issue.
No. But there's
It's simply a question of divorcing that from saying my son's a liar.
my lord, well, this
I mean I would be surprised if Mr. Reed took issue with the point that the conduct of religious organisations is not a matter of public interest, and in particular, in this case, the Plymouth Brethren doctrine of separation.
And I suppose that the issue, my lord, is whether preventing someone or committing someone for describing their experience through their direct experience, which inevitably involves the actions of their family, is a disproportionate interference with the right to communicate that.
No. It's whether a sentence of 14 days suspended for 12 months is a disproportionate interference.
Whether committing someone, my lord, yes, not whether the finding of contempt is, but whether the committal, absolutely.
So we're working here, I think, on the footing that the bargain that was made is not amenable to a challenge for misrepresentation, undue influence, any of the other recognised bases on which a bargain could be set aside.
It's no contractual basis.
And it's accepted that Article 10 does not of itself provide an exemption from enforcement of the lawfully made and otherwise enforceable bargain. So we're only talking about the enforcement of a sanction. And at that stage, the argument is that that which was put forward before and given up in the lawfully enforceable bargain is an answer to the sanction. That seems to be, as a general proposition, you can see the difficulty a court might have with that, because it's having your cake all over again for a different purpose. After you've had the main meal, digested it, and it hasn't worked. Terrible analogy.
No, I understand that. It may be a relatively short form review, and all those factors which your lordship has alluded to in the ordinary run of cases may well be decisive. All I say is that in common with every other public body, before you make a committal order, and the only thing I have permission to argue for your lordship is that a committal order shouldn't have been made. Before you make a committal order, you have to satisfy yourself that doing so would be proportionate and lawful.
I've just been looking at what the judge said in his sentencing remarks, and I think the reference to Article 10, maybe the only one, is in paragraph 46. It's on page 203, I think, where he referred to quadrilla.
Oh, yeah.
Yes.
So the line of cases about protest and conscientious motives.
Yes.
So to that extent, he took account of Article 10 or Article 11 as well. If this is a case of, it may be an Article 11 case as well. But you would say he didn't go far enough.
Well, I say he didn't. I mean, so the focus of Cordula, the reason it was correct is the notion, precisely as my lord has said, is the bargain of understanding.
Yeah.
An understanding that someone was doing it conscientiously.
And he gave it effect by suspending the penalty.
And they may not do it again. It wasn't discussed. I appreciate Article 10, and I think Article 11 as well was raised in this case, but it wasn't analysed from an Article 10 or Article 11 perspective, but by his lordship. The crux of his lordship's analysis was simply, this was a series of contempts that happened for conscientious reasons. I believe you that you're not going to do them again, and that's where Cordula comes in. It wasn't, in my respectful submission.
Yes, well, you're entitled to point out that by that stage he's already decided at paragraph 44 to impose a custodial sanction.
Yes, precisely.
Yeah.
So, my lord, can I just go through some of the other references in the supplementary bundle, which I say goes to the issue of the wider societal interest. And as I do so, I just want to highlight the right to Article 10 is not just my client's right to communicate these things, it's the right of the public and other people to receive information that he wishes to give about his experience and the effects the doctrine had on him. So, my lord, if we go please to paragraph 19, forgive me, page 19 of the supplementary bundle, paragraph 11. Ask your lordships to read that paragraph in my client's witness statement.
Sorry, page.
Page 19, supplemental, bottom paragraph, paragraph 11.
This isn't your client's witness statement because your client didn't give evidence. This is
He
the
did for sanctions.
statement that he put in, which the judge had regard to in relation to sanctions.
Yes, mitigation statement.
Yes.
Yeah, sorry, to speak of this wasn't before his lordship at
No.
trial.
Yeah.
So, I suppose there's 2 points here, my lord. First is the what I say is the difficulty in separating out the doctrine of separation in generality and the PBCC in generality and the specific role that his family, he says, was compelled to take. And then I say also in terms of proportionality balancing exercise as a whole, I say the last few sentences are significant. That his view is that his family are victims just in the way that he is. And these were not contempts that were done to cause harm, to cause embarrassment, to cause any damage at all. But rather, they are statements made out of deep conviction in respect to what he considers to be a deeply damaging institution. And my lord, just
Of which he was part.
my lord,
Of which he was part until he was expelled.
my lord, the history of his involvement in the PBCC was he was a member as a child. His father and siblings left, and and as a result of the doctrine of separation, he lost all contact with them. He was a member as well.
But he stayed in the church.
As
It
a
was only
child.
the events of 2017 that he left, or he was expelled. That's right, isn't it, as a matter of fact?
That's right, my lord. But he stayed in as a child, and the evidence, particularly of Dr. Jill.
Well, he stayed in as an adult. He was married in the church.
Yes, but my lord, it's common in cultic groups for people to become indoctrinated. To
Yeah,
remain-
that I understand. And it's common also for people who are expelled then to want to raise concerns, let's say, about the organisation from which they have been expelled.
Well, my lord, can we look then perhaps at page 3 of the supplemental bundle, because this is the witness statement of Dr. Abe Mitten, who is an academic and a psychologist. And I just ask you please to read paragraph 5, because this describes the effect that the PVCC had on her life.
Yeah.
And then when your lordships have that paragraph, I just ask you to turn to page 6 of the same bundle and just read paragraphs 18 to 21 if I could.
Yeah.
This is relevant to proportionality for a number of reasons. Firstly, again, it reinforces the public interest issue at stake. But secondly, a consideration when assessing proportionality, of course, is going to be culpability. Why the contempts took place, how important they are, how important speech concerned was, both to the individual from a self-fulfillment perspective and also that such speech should be protected in a democratic society. And I make 2 points arising from this. The first is, your lordships are concerned, as Dr. Rabbi Mitten says, with a man who is a member of a class of people who are often mentally unwell, with little financial means, and a sense of distorted reality. Committing a member of that class of people to prison, even on a suspended basis, doesn't just have a very, very significant effect on that individual, but it has a chilling effect. Because other members of that class who might wish to talk about what happened to them in the PVCC, the effect it had on them, will be deterred from doing so. That's contrary to the public interest.
Sorry. What others are there who've been embroiled in litigation of this kind and have given undertakings like this?
Well, there's a long list, my lord, of people who've been
No,
embroiled.
litigation involving a family company and a settlement reinforced by an undertaking to the court.
Well, my lord, I don't have a specific example of that, but if you look at paragraph 17 of this same witness statement, there's a long list of other litigation which has been engaged in by PVCC-controlled entities.
But why are people who have not given undertakings to the court going to be deterred or chilled by a sanction imposed for breach of an undertaking that has been given to the court?
Well, I understand the point. The point, of course, is that the average person will not be subject to an undertaking and then liable to committal, so why should it concern them? I think there are two answers. The first is it's made very clear in Mr Hastie's witness statement, is a lot of people, if you're in the PVCC, it's expected you work for a PVCC organisation. A lot of people will have contractual terms that PVCC companies can rely upon that has a similar effect to the terms at issue in this case. First point. Second point is, I say, what's clear from Dr. Mitten's evidence is that the average person who has left the church will not be in a position to make the distinction as clearly as your lordship makes it. What they will see is someone who's communicated ideas about the PVCC, has been dragged to court and has been subject to a suspended committal order. My lords, can we just briefly look at Mr Hastie's witness statements. It's
Well,
I'm so sorry.
I have endeavoured to try and hurry you up through this. I don't want to keep doing it.
No,
So do take us to some more references. It is not a rehearing.
I understand.
You have a right, you appeal as of right, as you say, but it is not a right to a rehearing.
I understand, my lord.
We didn't hear any of these witnesses.
I understand. The only reason I was taking this approach is because of the issue of potential remaking of the same decision.
We have already accepted the public interest point. We have drawn the distinction between that and calling your son a liar, putting it in shorthand.
My lord, I'll move on.
So just give us the paragraph references in this that you say are of.
I say 9 to 11 are particularly relevant, and then the other issue are just the other documents I just invite your lordships to look at when you come.
And this is right, is it, Mr. Hasty? Is it?
Yes.
He wasn't an expert.
No, he wasn't an expert.
So he was giving evidence even though he wasn't involved in any of the relevant events.
Well, he's conducted lots of research into the PPCC.
He wasn't involved in any of the relevant events in this case, which
No, he wasn't.
no. So it is slightly difficult to label precisely what evidence this is, but the judge, with some hesitation, allowed it in. So it's 9 to 11.
Yes. The judge allowed it in, and Malone didn't challenge the evidence and cross-examination, and the position is it stands as true.
Yeah.
It looks like hearsay evidence of fact to some extent, anyway.
Well,
Spoken to a lot of people.
spoken to it's not a direct account of the way Dr. Misson's evidence is of his experiences or his research.
I can't see what other category it could belong in. It's not expert evidence. And it's not direct evidence of anything he's experienced that's relevant. He's spoken to a lot of people. So that's the status of it. It's unchallenged hearsay evidence of fact that the judge has to evaluate.
My Lord, yes. I accept that. You have the press reports in the bundle as well at page 207 onwards. I say what all of this demonstrates, and I know you also accept it, these are matters of acute public interest.
I didn't say acute, I said public interest.
Well, I say, my lord, that they're matters of
Fine.
acute public interest because they concern the welfare of vulnerable individuals. They concern the activities of a religious group with a significant following. And I say, for all the reasons that Mr. Christie said in his witness statement for the sanction hearing, they're matters that it is a necessary precondition for his self-fulfillment that he's able to talk about these issues and to discuss the effect that the doctrine of separation had on his life. Now, the other point, just the last point I wish to make in respect of harm, is that there's no direct evidence of harm whatsoever in this case.
I do find, in the circumstances of this case, I find that a very surprising submission. You're saying that there's not evidence from Jed and Josh saying, I took to my bed for a week because my father called me a liar and that I'd burn in hell.
Well, my lord, he didn't say that he'd burn in
You
hell.
don't get evidence of harm. That's a matter for the judge.
Well, my lord, there's two issues on harm. The first is, my client did not say Jed is going to burn in hell. What his lordship did in the judgments, he looked at revelations and he made an assessment on harm, partially based on his lordship's interpretation of a verse from Revelations. I say respectfully, that's an unusual approach to take in assessing the level of harm associated with an alleged contempt. The second point I make is that the evidence of the respondent's solicitor was that her firm, quite absolutely properly, did a search for the terms of the documents for things that might give rise to contempt. It's not even suggested, it's never been suggested anywhere that the contempts or the comments came to light or came to the attention of the respondents for any other reason than that. Thirdly, his lordship did say it was an unusual feature of this case, that there was a lack of evidence on harm. But secondly, my lord, if we go please to Chow, Crown and Chow, at page 469 of the authorities bundle, paragraphs 21 and 22, when you get there, please. Second half of paragraph 21, there's a requirement for a judge to act on the evidence before making a determination as to the level of harm. If there isn't sufficient evidence,
This is a criminal case.
well, my lord, it is, yes.
And a lot of your submissions are how they are not, you don't read them across.
I'm sorry, my lord.
Sentencing guidance.
Well, the ASB guidance is for civil contempts, but the principle, I say, is the same in Chow, which is that there has to be some evidence upon which you conclude that there's harm and a certain level of harm. And save where it's an obvious inference can be drawn from the nature and circumstance of the offence, a judge should not make assumptions as to the effect of the offence on the victim. That's paragraph 22. My lord, I say, in circumstances where it had been said in evidence and the judge accepted that this only came to light, or that this came to light because of a search conducted by solicitors, I don't say that. I say that the circumstances of the offence were not such, or the circumstances of the contempt were not such, that it could be obviously inferred that it's medium harm, and therefore the default position is there should have been an assumption it's low harm. So, my lord, for all of those reasons, I say there should have been an assessment of proportionality. I say because of both the public interest and the personal aspects of the matters discussed, of the nature of the communications complained of, this case did fall into an exceptional category where, notwithstanding the pressing public interest of enforcing the finality principle, it was disproportionate to impose a custodial sentence on the specific facts of this case. My lords, can I move on to ground 2?
Yes.
I think the first issue I have to address is whether I require permission to argue ground 2. It's said by my learned friend that because this was the contempts concerned, those being the first and 19th contempts, did not lead to a custodial sentence. I'm not entitled to argue.
Well, no penalty at all.
Well, I suppose, my lord, that I can take this fairly shortly because if your lordships aren't with me on the points, I won't push matters any further. But page 204 of the core bundle. Paragraph 54, when you get there, please.
Yes.
Now, in my submission, what his lordship is saying here is that the contempts over which no penalty was formally passed were taken into account in the custodial sentence that was imposed, and therefore I say form part of the reason for the committal order. I say it follows from that my client doesn't require permission to argue.
But sorry, he says in the second sentence, no separate penalties should be imposed. You're right, he says take it into account. He then reiterates no further penalty is imposed for the balance of the contempt. So therefore, where that leads us to is that even if we were to allow the appeal on ground 2, it would make no difference.
Yes.
And isn't that quite a good way of testing whether you need permission?
Yes, or whether it's a good use of your lordship's time.
Well,
Spend
that
time
too.
discussing now. If you're content, perhaps I'll just move on to ground 3, my lord.
Just one point on ground 2, if I may. You say that the judge accepted in the sentencing remarks the question of lack of intention.
Yes.
Where's that?
My note, so my lord, to explain, my note differs materially from. There's no transcript.
Well, I understand that.
And my note, at the point I drafted the skeleton argument, my note differs, that I took in the hearing, differed from the note which was ultimately agreed between the parties.
Okay,
The
so
point at which I
This was approved by the judge.
so and my learned friend said it's been the sentencing note that your lordship now has been approved by the judge. It's fair observation.
so you accept that the sentencing note does not say what you said in your skeleton argument.
My lord, I do. Can I just take you to the part that's the answer is yes, my lord.
So just, I mean that's sufficient for my purposes. But if you want to give that context, by all means, refer me to the paragraph.
I'll give you the reference. I won't ask you to turn it up. It's page 197, core bundle.
So it's page.
197, core bundle,
Yeah.
paragraph 16.
Yeah.
The formulation of that paragraph I had in my notes went further than what was ultimately approved by his lordship and what was recorded by my friend. I suspect that's narrow in my note taking.
Yeah. Fine. All right. Well, that's very fair. So because I read 16,
Yes.
and it seemed to me quite clear what it was saying, and therefore, hence my question. But you've answered that very fairly, so that's fine.
My lord, the third issue, ground 3, and comes to the time, is the question of improper collateral purpose.
Yeah.
Now, I think it is common ground, as between the parties, that if these proceedings had been brought with the predominant purpose of stifling, preventing, or obstructing criticism of the PVCC, that would amount to an improper collateral purpose and would justify strikeout. Now, I was going to take your lordships to what Mr Justice Cotter had to say about this, but I'm not going to take all the time. So
I think it's paragraphs 83 to 86, something like that.
yes, that's right. So I think
Towards the end of the judgment.
so I think it's dealt with on page 88 at Roman numeral E. Sorry, letter E. Yes, it's 86. Forgive me, it's 86. Paragraph E. And then I think 92.
It's 84 to 85, isn't it? Yeah.
Yes.
Abuse of process collateral purpose.
It's dealt with earlier on. Then exactly right. It's 84 to 85. Now, my lord, in the course of his judgment, Mr Justice Cotter said it's impossible to see what possible relevance the evidence of Dr Mitten and Mr Hastie would have, and really the extent of ground 3, as I argue it today, is that his lordship was wrong to conclude that Dr Mitten and Mr Hastie's evidence was of no relevance, that it established a prima facie case that these proceedings may have, or indeed were likely to have been advanced for an improper collateral purpose. And I say that there's a duty on the court to be astute and to be vigilant when there's a possibility that proceedings are being advanced for an improper collateral purpose. Now, I appreciate what my Lord Justice Coulson said about this not being a rehearing, so I'm not going to go through all of the references, but can I give you some references for your Lordships to read when you consider your judgment? I say that paragraphs 8 to 16 of Dr. Mitton's witness statement, which your Lordships find at paragraph 4 of the supplemental bundle, sets out clear examples of the PBCC using similar legal tactics against Dr. Mitton. At the page 5 of the supplemental bundle, there's a list of the PBCC and PBCC controlled entities using similar legal tactics against a whole host of other critics. Then at paragraphs 22, 23 and 27, which is a paragraph that starts at page 7 of the supplemental bundle, there's a clear explanation from her academic experience of how PBCC and cultic groups use the courts in this way. At paragraph 29 of Dr. Mitton's witness statement, there's an explanation that Mr Christie is a well-known and prominent critic of PBCC and the chilling effect it will have. And the evidence of Dr. Mitton is that it is likely that these proceedings were being used as a means of stifling and preventing criticism of PBCC. And at paragraph 27 of her witness statement, the Lordships will see that she says that has been an effective strategy. Then the evidence of Mr Hasty, and I'd invite your Lordships to read his evidence in full. And I absolutely appreciate the point that he may not have had direct experience or knowledge of the matters in this case, but my lord, the evidence he gave was uncontested and is taken to be true. I say his evidence, when read in it is absolutely clear that Weavabel Group would not have had the autonomy to bring these proceedings on their own account without the approval or direction of PBCC, that it is very likely that these proceedings are being used as a means of stifling or repressing commentary about the PBCC. And his evidence is clear that as to what the likely purpose of these proceedings were. So you had two witnesses who have given uncontested evidence, one of whom has very extensive personal experience with PBCC, the other has done a very high degree of research into the PBCC, spoken to a lot of members of the PBCC, and their clear and unequivocal evidence, my lord, is this is absolutely straight out of the PBCC playbook, that the respondent would not have the authority or the autonomy to bring these proceedings without the PBCC's approval or direction, and that it is highly likely that the true motivation, the predominant purpose of these proceedings were not to vindicate the respondent's rights, but rather to stifle, prevent and oppress criticism of a religious organisation. And it's common ground that if that was the purpose, then that amounts to an abusive process. Now,
can I just be clear about which proceedings we're talking about? Because this criticism could be made at various different stages.
yes,
Or could have been made. It could have been made in relation to the proceedings that led to the undertakings. It could have been made in relation to the enforcement of the undertakings.
yes.
What's the proposition?
I'm saying that this contempt application.
So it's not part of the argument that the underlying proceedings or the extraction of the undertakings in the first place, which you accept to be lawful, involved any abusive process.
That's not
An
part of my
attempt to enforce them was. That's just for clarity. It's not casting any
Yes,
doubt.
no, my lord, that's right.
Not seeking to express a view about it.
No, I understand. Yes, my lord. I'm not arguing that the undertaking proceedings amount to an abuse process. I'm simply saying that the committal order was, and I say with respect, there's a. I don't really go any further than saying those witness statements raise a prima facie case that these proceedings may have been an abuse process. I say that there's clear authority from Sex Guard and subsequent cases that there's a duty on the court to be astute to ensure that proceedings aren't brought for an improper or collateral purpose in a contempt context. And I say that his lordship erred in finding that the evidence of Mr Hastie and Dr Mitten was of no possible relevance. And I say as a result of that error in failing to identify the relevance and significance of that evidence, which was unchallenged, his lordship fell into an error of law and didn't properly assess and consider that evidence. So this isn't
Could
a
have been
case-
unchallenged because it was thought to be irrelevant. So the fact that they're two different things. You say it was relevant.
My lord, yes. Can I just on that point? It's a fair point. Can I just ask you to turn up, please, page 155 of the supplemental bundle, and it's internal pages 142 to 143 when you get that.
Yeah.
And the point is, this is after my learned friend indicated that he wasn't intending to cross-examine the witnesses. And I made the point that, well, if you don't cross-examine them, they're taken to be true. And your lordships will see there's an exchange between my learned friend, the judge, and I. And it's common ground, I think it was accepted by everyone, that, well, you hang your hat on relevance, but if you're wrong about them being relevant, they're taken to be true, they're in.
Yeah.
And
So
I say
repeat
that
the
his
point.
lordship,
it's all about relevance.
exactly, precisely.
That's what I said.
And I say I accept that. And his lordship, I say the error of law, where his lordship was wrong, was failing to identify that those witness statements were relevant. Of course, it would have been open to his lordship then, having decided they were relevant, to decide what weight to place on them or what approach to take to them, etc. But he never, in my respectful submission, he never really truly got to that stage, because he dismissed their relevance at the outset. So it's not, the point I'm trying to drive at is this is not, as it suggests in the respondent skeleton argument, a challenge to a finding of fact by the judge, where he's carefully weighed the evidence and come to a clear conclusion. It's a case where, with respect to his lordship, failed to identify the relevance and importance of evidence, and therefore failed to give it any weight whatsoever.
What I'm finding a bit difficult is what the judge is supposed to do. Suppose he says, well, here's some prima facie evidence, but not enough to justify a finding of abuse. I don't think you're challenging the judge's conclusions on the burden of proof. So
No.
what happens then? Is the judge supposed to investigate? Or just make a finding on what the evidence shows?
It would have been open to his lordship to say, this is relevant evidence, this is the test for improper collateral purpose. I accept it's raised an issue, but taking into account all the circumstances of the case and all the evidence I've seen, I'm not satisfied that it is an improper collateral purpose. That conclusion would be very difficult, I accept, for me to challenge, but that's not the situation we're in my respectful submission. We're in a situation where his lordship didn't even accept that the evidence was of potential relevance.
But you're challenging the decision, not the reasons.
My lord,
So
yes.
that line of reasoning would have resulted in the same outcome.
Well, my lord, I say, I do say that the evidence of Mr Hastie and Dr Mitten being unchallenged and then therefore taken to be true, combined with the context in which the speech complained of was being made, i.e. all entirely focused on the Plymouth Brethren Church, all entirely focused and directed towards current or former members of the Plymouth Brethren Christian Church, is sufficient for the court to conclude that it's pursued for an improper collateral purpose. There was no rebuttal evidence called, there was no challenging cross-examination, there wasn't even a submission advanced that the evidence was factually wrong. Everything was focused on relevance. My lords, I said to my learned friend I would speak until about 12:30, so I have a few moments left. ground 4 is sentencing.
Well, you've dealt with most
So
of
I
this
think I've largely-
effectively along the way, I think.
I think so, my lords. I think the only point in sentencing I probably need to address very briefly is the antisocial behaviour order guidelines, which your lordships will find, please, page 107 of the supplementary hearing bundle.
Not in the authorities.
So sorry, it's in the supplemental hearing bundle.
Okay. 107.
Yes.
Yeah.
And the point is, these are sentencing guidelines which were devised for dealing with civil contempts arising out of breaches of antisocial behaviour orders.
Yeah.
Your lordships have my point, I think, made in my skeleton argument that antisocial behaviour is a societal issue which Parliament was sufficiently concerned about so as to litigate. There are different considerations, I say, in the context of antisocial behaviour, as opposed to the enforcement of an undertaking given in quasi-commercial litigation. So I say that although on one view these guidelines were useful, there should have been a downward adjustment to reflect the very different context in which the contempts in this case arose. And at page 111, you get the guidelines. His lordship found that it was between culpability between B2 and 3. So culpability B and between 2 and 3 levels of harm. That was the conclusion in the judgment, which I'll take your lordships to in a moment. And you'll see that would have given a starting point of adjourned consideration, category range of adjourned consideration to 1 month, being right at the top end of category 3, bottom of category 2. And I say that the sentence which was imposed by his lordship fell squarely in the middle of that range. And then I say, if one looks at tab 15, again for core bundle.
Sorry, the middle of which range?
I say it's bottom of B3, bottom of B2, top of B3.
Three months to 1 month.
So B3, adjourned consideration, category range, consideration to 1 month.
Yeah.
And then starting point, 1 month, but adjourned consideration to 3 months.
Yeah.
Being category 2.
And here,
so
it's,
I say
here it's 2 weeks.
I'm sorry?
Here it's 2 weeks.
Well, here it's in the middle of the range, my lord, I say, between adjourned consideration to 1 month, or it's right at the bottom of B2.
Okay, but the range, the upper range, is between 1 to 3 months.
The range of B2 is adjourned consideration to 3 months.
Yeah.
So so if a judge concluded that
You're taking adjourned consideration to mean nil.
well, adjourned consideration is not nil. Adjourned consideration is
No, but for the 2 weeks to be in the middle,
yes.
you must be taking it to be nil.
Well, yes, effectively, yeah.
I'm sorry, I'm just reflecting your submissions back in terms of the maths.
Yes.
Yeah.
That's right, my lord. But I say that if a judge was dealing with an ASB case and he concluded that you were at the bottom of category B2 or at the top of B3, then the sentence that this judge passed is pretty much precisely where you would land in my submission.
For one offence? For one breach?
One breach.
How many were there?
Well, there are many more, my lord, but there are no penalty for the vast majority.
How many were just remind me how many attracted the 14 days?
There's one. It was only one.
Just one, was it?
There were 13 of the 16 samples were found to be contempt, but only one. It
Yes.
was only contempt 20
Yes.
that triggered the thing. So obviously there's the argument on ground 2, but to the extent that there are other contempts in play, and they may not be, but if they are, then there are another 12.
Yes. And his lordship found there was no penalty due on those.
No, well, that goes back to the
Well,
point.
if we're with you on your permission, then it slightly undermines this argument, but if we're not, it helps you.
Yes. Well, can I just sum it back for a minute? So, my lord, just looking at page 202 of the core bundle, please.
$202, yeah.
Yes, 202, paragraphs 41 onwards. His lordship says he's gained assistance with the antisocial behaviour injunction sentencing guidelines. There's no reference there, and I'm aware of the risk of over-analysis of the judge's reasons. Of course, no judgment ever contains all the reasonings, but there's no reflection there, I say, of the very different context of antisocial behaviour injunctions and breaches, as opposed to cases of this kind, which are essentially arising out of private law issues.
So what did you refer him to in your?
My lord, I stated expressly in my sentencing notes that I referenced the antisocial behaviour guidelines and said that there needs to be a downward adjustment.
So remind me where your sentencing note is.
It's tab 19 of the supplementary bundle at 266.
And it's paragraph.
Paragraph 3 is when it starts out, and then I'll just find.
No, so you were putting it forward.
It's paragraph 21, my lord.
Yeah, but it is submitted. There's no principal reason why this guidance should not also inform the court's approach in cases such as the present.
But my lord, that's not in. That's the mechanical approach of how you arrive at a conclusion in terms of culpability and harm and everything else. It's not the sentence that should be applied.
No. I'm back a stage.
Yes.
The relevance of these guidelines. You said in your note that these were the relevant guidelines. There's no principal reason why this guidance should not also inform the approach in this case. And then, so that's the general. Well, you make some general points about that at 3, 4, and 5. Do you pick it up again? Yes, there we are at 21.
21.
Right.
Antisocial behaviour injunctions carry specific considerations which do not apply here. They concern conduct which harms the wider community, conduct which Parliament has felt the need to specifically legislate to combat, and conduct which may often involve some degree of criminality. None of these considerations apply here. So
The consideration that does apply here is that this is a contempt of court.
yes, of course, but so would any breach of antisocial behaviour injunction.
Anyway, that was the submission.
So the submission was that there's a distinction to be drawn. A breach of antisocial behaviour order is a specific form of contempt that has a wider societal impact and that Parliament has expressed particular concern about. Those considerations do not arise in a private law context, and therefore you can't simply mechanically apply the same sentencing guidelines. And I should explain for context, my lord, the reason they refer to paragraph 3 of my sentencing note is there, as far as I can find, as far as I'm aware, that the only sentencing guidelines which relate to civil contempt at all. So when they set out the general approach of determining the degree of culpability, harm, etc., they provide useful guidance in that sense, but they don't inform, in my submission, the custodial sentence that should be imposed following a private law finding of contempt.
No. On the other hand, the protester cases
Yes.
where there are contempts which some would argue were driven by conscience.
Yes.
Those are, of course, measured now in months and sometimes years,
They are, my lord. But again,
which I don't think anybody would suggest first time round would have been appropriate here. But I recently had to do a grid of where those sentences come out, and they're certainly much, much higher than 2 weeks suspended for a year.
yes. Again, of course, there's a distinction.
There are always distinctions, of course. I'm just trying to think of what other body of law might be an appropriate
Comparison.
comparator.
Yes.
Yeah, okay.
But the problem with contempt of court is the circumstances are so various. And
Yes.
so, for example, there's been quite a lot of cases on breaches of freezing orders.
Yes.
And some quite severe penalties have been imposed in those cases.
Yes. But absolutely, my lord. And breach of freezing orders provide useful examples of where the harm's absolutely obvious. Can be fairly inferred, and the level of harm that's caused is fairly reflected in the principle there should be an immediate custodial sentence because people lose the fruits of their judgment. And of course, I'm not submitting to one moment that the court is not entitled, and in appropriate cases should not impose lengthy custodial sentences for contemptuous behaviour. I absolutely accept that contempt of court does strike at the rule of law and does strike at the authority of the court, and the court needs to take robust action when it's appropriate. So I simply say in this case it wasn't appropriate. My lords, can I assist any further?
I was just going to mention the application that's listed that you were puzzled about.
Yes.
I think it's your application or your client's application for permission to appeal on costs, according to the information in front of me, which is contained in the appellant's notice. I think our view was that there's no separate issue about costs. It's simply a question of whether you succeed on the appeal.
Yes. I think what may have happened, my lords, is there was an application for a stay of the order, or the cost order of Mr Justice Cotter. That was resolved as between the parties, and my Lord Justice Coulson sealed a consent order resolving that application. So I think it may simply be that that's been listed in error, because I don't think it remains an issue between the parties. Great.
I don't know none of that. No, thank you very much, Mr Hitchens. Yes, Mr Reid.
My lords, taking grounds 1 to 4 in that order. Obviously, ground 4, the ground has shifted somewhat in that, whilst helpfully, my learned friend has limited it to the impact on sanction today. It was in the appeal, and it is a skeleton argument on the appeal, raised very squarely on the basis that Article 10 was impacting on both the finding of the contempt and the imposition of a custodial sentence, and that's most conveniently taken from paragraph 2A of my learned friend's skeleton reference. I don't need to take you to it. It is in the core bundle, tab 3, page 17. So obviously I was going to spend some time tackling that in terms of the impact on the finding of contempt, but I don't think I need to do that.
No, because it's accepted the judge did nothing wrong on this ground, down to and including his finding of liability. The challenge is to the sanction.
My lord, yes. And I say that's, for clarity, a concession well made, because on the primary ground, another way of looking at it is there's the rule in Chuck and Kramer, as I've called it, and explained by the Supreme Court in Major and Secretary of State for the Home Department, namely that you have to, whether you are government minister, private individual, you have to obey an order or an undertaking to the court unless and until it's varied and set aside. And what I say in simple terms is, well, there may be circumstances in which you need to carry out a fact-specific balancing exercise, the proportionality balance, but actually that rule will always trump Article 10 in these cases. You don't need to say that there's some fact-specific analysis. Actually, that's a rule of such fundamental importance to the rule of law that will always outweigh Article 10. So that's how I put that. So that's why I say it's a submission well made. Now, In terms then of what the judge said about it at the sanctions hearing, well, I think one needs to go back in view of the way the argument's now put to what actually was before the judge. My learned friend showed you what he said in his skeleton argument. I think it was at paragraph 10 of that he raised the point.
20, but yes.
Sorry, I apologise. But that, my lords, was it. Now, we've got a note of the submissions that was before Mr Justice Cotter at the sanctions hearing. That's actually in the bundle at tab 20. If you go to the supplemental bundle, please. At tab 20.
Just before we delve into the detail, Mr. Reed, can I just sort of, as it were, see where you are on the point of principle?
Yes.
Given the way the argument is now framed, let me ask you a hypothetical question. Hypothetically, if the judge had imposed a sanction of 2 years imprisonment for this contempt, would you be disputing that engaged Article 10?
No, and I'll explain why. I accept that Article 10 is engaged in that sense. In this sense, the court as public body is always bound in any of its decisions to take into account the various articles of the convention. And one of those is Article 10. Now, there may well be cases in which Article 10, whilst it has to be considered, isn't actually engaged. The rights of freedom of expression aren't engaged at all. And I accept here where it relates to it's a sanction relating to expression, it is engaged in that sense. Right. The question is, what is the... and it would be engaged even at 14 days.
It must follow from that a proportionality assessment would be required.
Yes. And what I say is a proportionality assessment. I think my Lord Justice Coulson said, well, of course, the judge will always be taking into account proportionality when it comes to sentencing. And what I say is that is one of the factors that comes into the mix here. Yes, it needs to be proportionate. Proportionality includes being proportionate.
Yes.
To the Article 10.
So where we're going to end up is you will say that a sentence of 14 days suspended for 12 months is not disproportionate.
Exactly.
Yeah.
Exactly. And the point, perhaps my Lord, that was helpful with respect. My Lord may have feared I was going to the weeds, but actually, what I was going to show my Lord is just how short the submissions were before Mr Justice Cotter at the sanctions hearing. They're at tab 20, and my learned friend's submissions start on
Tab
page
20.
So tab 20 of the supplemental bundle. I should say these have been agreed by counsel because whilst we'd arranged for there to be a transcriber, Mr Justice Cotter decided he didn't want to approve there being a transcriber, and the court machine was not recording, so we did this from our own notes and solicitors' notes. And
Did on behalf of the court, I'm sorry about that. Did you know during the hearing on the 1st of November that the machines weren't working?
No. You see, we'd arranged for a private transcriber, to which the judge said, we don't need that, everything's recorded anyway. And then it was later found out there was an error.
Technically, he was right about that, but
belt and braces might
this is the third appeal I've done in a fortnight where an important ruling, in this case the sanction judgment, was not recorded by HMCTS. So it's important to know. Well, as I say, I can only apologise. So anyway, these are the notes of submissions,
and they've been agreed between the parties.
right?
So that's the context. As I say, my learned friend's submissions start. So I went first, as it were. My learned friend's submissions start on page 277, and finish on page 278. That's it.
Mm-hmm.
Sanctions hearing.
Well, because of course you put in written notes in advance.
Absolutely, and they're both in the bundle as well, my lord. They're in at tabs 18 and 19. My point was simply going to be this thing. My learned friend doesn't separately pick up in oral submissions on the Article 10 point. That's not to say you can't run it. The court is duty bound as a public body. As I say, if Article 10 is engaged, it has to take into account. My submission, though, is going to be this. In every judgment handed down, every day of the land, it has to be compliant with the convention. But that doesn't mean to say that in every case, a judge will say, I've considered Articles 2, 3, 4, and so on. The judges sensibly focus on, in their judgment, the points that have raised before them. And if a point's raised lightly, it's often dealt with lightly in a judgment. And so I would say, my lords, when one's looking at the sentencing remarks, that undoubtedly, in my submission, takes account of the fact that it was a single paragraph raised by my learned friend in his written submissions and nothing in his oral submissions. So that's the relevant context, I say. And the judge will have been well aware of the need, of course, to ensure that his sentence was proportionate. Now, when
he does refer to Article 10, albeit, as my lord pointed out, on the question of suspension expressly, but it would appear, therefore, that he was aware of Article 10 and its potential relevance.
Exactly, my lord. I don't want to take the point too far, but as my Lord Justice Coulson says, he was aware of it. And of course, he was aware of the principle from the liability hearing, albeit in a different context. But it does show he had Article 10 in his mind at the sanctions hearing. As you say, he mentions it in his judgment at that latter stage. But it's also worth noting that he was alive, Mr Justice Cotter was alive to the points about expression, and indeed whether what he was giving the sanction for was about the broad public policy criticisms, might be said, that the appellant was making about the PBCC, or was it some narrower complaint? And here we see at paragraph 2 of the sentencing remarks, that's in the core bundle, tab 15, page 194. He says about that he's in paragraph 2, relevant history has been set out in his lengthy judgment, which should be read separately. And in short, Lance Christie continued after the hearing to make wide-ranging comments about the PBCC, something he was entitled to do, and of course about which no complaint was made here. But he also made derogatory comments about his family, something he was not allowed to do by virtue of his undertaking. And that goes to the point that my Lord, Lord Justice Coulson made about the distinction between criticising the church on the one hand and saying, my son's a liar on the other. And again, the judge's laser-like focus on what is it that I'm giving the sanction for. So actually, it's a narrow interference. So to put it another way, if one takes the protester cases where, whether it's climate change or something else, that is a sanction that is interfering directly with that point of public interest.
Yeah, and the judge
here
reiterates that point at paragraph 5 on the next page.
That was my lord's ahead of me.
Yeah,
that's exactly the point. So what I submit is, whilst he wasn't saying in overt terms, I'm now addressing my mind to Article 10, he was he was expressly dealing with matters, the factual matters that underlie that analysis, albeit he hasn't expressed it and said, well, I've taken these into account and it's not an undue interference with Article 10. He's taken the relevant facts and matters into account, I say. So given where the argument on Article 10 has now led, I don't think there's much more I can assist the court with. I submit that given what the judge had faced, given the arguments that had been put to him, he properly took into account the relevant considerations, namely the relatively narrow, I say, interference. He took into account that this was a breach of an undertaking given to the court, and that his sanction was appropriate in the circumstances, and specifically, I say it was proportionate and compliant with Article 10. Well, unless there are any questions, I propose to move on to round 3.
Hang on a minute. So I was unclear. Was that ground 1 or ground 4?
That was ground 1.
So that's ground 1 as it's now.
As it's now put.
It's now put. I understand.
Yes,
that.
I'll
No,
deal
no,
with
it's just a question for my headings. Mr. Hitchen's been in front of me before. He knows that I'm very keen to make sure I get my headings right. So I've headed that. I put ground 4, but I crossed out 4 and I put 1. And that's right.
Ground 1 as amended.
Fine,
Yes,
good.
as narrowed.
Fine. So then you were going to ground 3.
3, because ground 2 isn't pressed anymore. That was the my learned friend didn't seek permission to
The mens rea.
the mens
Well,
rea point.
he accepted it was essentially academic anyway.
And he also properly, fairly concedes the point about what the judge said in the agreed sentencing note about the mitigation statement, which is the point that before I got that answer, I was a bit concerned about.
Yes, my lord.
But I now see that, and that's fine. So okay. So you're not going to say anything more about ground 2.
I don't think I need to.
I mean, I mean, to the extent that it's in play, the skeleton argument set out the submissions.
My lord, yes.
All right, so we go to ground 3, the improper collateral purpose.
That's it. Now, starting, what I think my learned friend says is first that the judge erred in law in his approach. Secondly, that the judge failed to give sufficient regard to the appellant's evidence, and thirdly, that he reached a wrong conclusion. Now, as to law, the appellant set that out in paragraphs 39 and 14 of his skeleton argument, and none of those principles are contentious. It's of course
Sorry, say that again. What's the paragraphs?
It's 39 to 40. So that's core bundle.
Of the appellant skeleton.
Yes, my learned friend skeleton. It's tab 3 in the bundle. I can take you all to them very quickly. It starts on page, so it's core bundle, tab 3, page 33.
Yeah.
The uncontroversial propositions. And I don't think my learned friend says the judge didn't consider any of these, or obviously they weren't overtly set out, but they're not controversial legal principles. It's where the court's process is being used, or rather misused, for the predominant purpose of achieving something not properly available to the claimant in the course of properly conducted proceedings, as explained in Wallace. And what one can give different examples to illustrate the point. Of course, there may be many and varied, but my learned friend gives the example of someone trying to extort the defendant's property in Hollyoake and Candy, which my learned friend wanted in the bundles. Mr Justice Nugee, as he then was, put it under the heading of extortion under the colour of due process. And there are various different examples in the cases. For example, trying to designing proceedings with the intention of improperly securing for the claimant a ship's register. The claimant had no proper entitlement to it. The whole proceedings were designed to achieve that aim. It was they're colourable proceedings for an entirely different purpose. And we say, actually, that's simply not in point here. The obvious predominant purpose of these proceedings is because the family members don't want derogatory comments made about them. They want the benefit of the undertaking that the appellant gave to the court, and realistically, having sent a letter after the undertaking has been given, when they considered there was a breach, there was a letter between solicitors, and Mr Justice Cotter refers to this, the shot across the bows. It wasn't taken seriously, unfortunately. Further serious comments followed, and I would submit, unsurprisingly, the company brought these proceedings. That's the natural. That is the purpose, and it's the obvious inference to be drawn from these. So when one steps back, the question is, what else are they trying to achieve, and is it plausible? Now, before I go into the merits, I would say there is some authority for the proposition that the merits can be a relevant factor. Not that they are always, but they can be a relevant factor when assessing whether there's an improper collateral abuse. For that, again, I don't propose to take my lords to it, but it's in Navigator Equities, it's in the bundle at paragraphs 102, 103 and 105. And the essence is it's fact specific. Now, of course, sometimes abuse of process applications might be made on a strikeout basis, so as an interim stage, or they might be dealt with at trial.
Navigator, that's the Lady Justice Carr, she then was.
Yes.
Decision. And that, am I right in recalling that also talks about motive?
Yes, it does, my lord. It deals with a number of points. It talks about whether, when there's a mixed motive, what's the court to do, and concludes that it has to be that the predominant motive is the improper one.
Yeah.
Her ladyship explains that often there may be unhappiness, to put it mildly, at the party bringing the contempt application. Then there may well be a hostile animus between the parties. That would be unsurprising where a court order has been breached, but that doesn't matter. It's whether the predominant purpose is the improper one.
For improper collateral purpose.
Yes.
Yeah. So you were referring to it because merits can be a relevant factor.
Yes, and it depends on the circumstances. There may be some cases where the merits of the action are utterly unhelpful to determining whether or not it's an abuse, but in some cases there might be. And the reason I mention that is here I say, look at the substance of what I've done. Are these a bunch of technical contempts that, whilst they might barely cross the line, that's to say, that it's not disproportionate to bring a contempt application, is this the proper stuff of a contempt application? And in my submission, these really were serious. They were accusing the sons of being liars, perjurers, and so on, and not just on a one-off basis, on a repeated basis. And the judge rightly rejected the submission that this was disproportionate, and there's no appeal from that. And as the judge pointed out, much of what made it a lengthy hearing was the various defences being advanced by the appellant, not the contempt itself. But for present purposes, I come back to this. Well, the decision maker is entitled to say, does this look like a collateral purpose, or is this actually something that looks like a proper action? And I say, in the circumstances, it's serious, and it was an action with merit, and that points away from it being an action brought for some other collateral, some other purpose. Now, of course, in terms of the context, there were no pleadings from my learned friend. I'm not saying there needed to be, but of course, on many strikeout applications, it would be the defendant, the person making the application, that would plead it out in an application notice, and so one would know, and there would be evidence in support. Here, of course, the allegation was actually brought in after I'd put in my trial skeleton argument, so that's why there was no evidence on it, no written submissions from me. It was we found out about it, well, very shortly before my learned friend served his skeleton argument, which came in at a late stage. I don't blame.
So you found out about the improper collateral purpose point.
Well, actually, on the Article 10 point as well, but for present purposes, this as well. Yes. So, I'm not complaining about it. We didn't seek an adjournment. We got on with it, but it's part of the context. So the judge only had the benefit of oral submissions from me on this point, and my learned friend never had to commit in writing, as in a sort of pleaded case, what he was saying one's got his skeleton argument in his oral submissions. So that's part of the context. Now, how did the judge then deal with this? Perhaps if we could turn to his judgment, it's in the Court Bundle tab 5, and I'm going to start at paragraph 66D, which is on page 86. Now, essentially, the narrow formulation he says this at D. The undertaking was made with carefully carved out exceptions to ensure that Mr Christie is not prevented from making obviously legitimate comments in certain circumstances. This shows the keen focus at the time of compromise on what could be said and what could not be said. In such circumstances, there's obvious difficulty with Mr Hitchin's argument that ensuring Mr Lance Christie does not make derogatory comments is not the dominant purpose behind the current application. Also, the bringing of the committal proceedings for the purpose of achieving the natural consequences of the litigation, a fortiori the claimant's main aim within the original action cannot be a improper purpose. So I say the judge made no errors there. He's well aware of the relevant considerations, and actually it's entirely right to focus on the undertaking that was given. Let's go back to what was given to to His Honour Judge Gosnell. It's not some broad, ill-defined undertaking. It's actually relatively narrow, and by that I mean it's simply making no derogatory comments, no reference at all to members of the family. It was a point I was going to make in the context of Mionis under Article 10. The restriction there was much broader. That was a prohibition against mentioning Mr Mionis or any of his family at all. Couldn't refer to them. Here it's just restraining derogatory comments about them. And moreover, there were some carefully crafted exceptions because, as the judge here observed, the parties had keenly focused on it. That's relevant because, again, it's part of the background. Does this smell like a case where my clients are seeking to get the broadest possible undertaking or seeking to enforce it in ways that goes beyond its proper ambit? No. Been given very keen thought, and as the judge says here, there were carefully carved out exceptions. Then, continuing at sub-paragraph E, he says this undertaking does not prevent Mr Lance Christie making comments about PBCC Plymouth Brethren members, although it's clearly the case that Mr Christie and some of his supporters would wish to portray this in application as another attempt by the PBCC to silence a critic of the Church and prevent a legitimate comment about its practices and the activities. The undertaking does not even mention the Church. The content of some of the lengthy documents produced by Mr Christie since he gave the undertaking includes some wide-ranging attacks upon the PBCC and what he believes to be the improper activities of its leaders. However, it is not, and could not ever be, part of the claimant's application that Mr Lance Christie is critical of bravery and breached the undertaking. Now, the relevance of this, my lord, is that the respondent is not, on the face of the application, seeking to go beyond what I would call the four corners of the undertaking. Imagine, forensically, what a party seeking to abuse its undertaking might do. They might push the limit of this. Now, of course, whilst one can't settle contempt applications, imagine if my client had pleaded as derogatory comments, things that went beyond that which they could legitimately claim about. Then one might start to say, okay, you're trying to push this beyond its proper scope and you are abusing the court's process. I think it might be a difficult argument there, but it would be the start of an argument. Here, actually what the respondent has done is stuck squarely within that which is properly the subject of an undertaking. It couldn't have gone any further. It's not trying to go any further. So again, I say it's another pointer away from there being any improper collateral purpose. There's no improper relief things or something like that. Then, moving later in paragraph E, the judge says this. That is the limited. So this is over on page 87, about 5 lines, four at the end of the 4th line down. That is the limited extent of his promise. It goes no further. I should add that when it's argued that the claimant has an ulterior motive in bringing this application, it's difficult to see what the claimant could hope to achieve beyond holding Mr Christie to his own solemn promise. I cannot accept the argument that the true motive of the application is to prevent Mr Christie commenting generally about the brethren, as he has done so and remains free to do so. And then he goes on in reaching this conclusion, I do not underestimate the public interest in the rules and practices of religions and their effects on adherents of the wider public. So, of course, he's well aware of the public interest point in terms of wider allegations, but this is limited to the narrow point. So again, completely points away from improper collateral purpose. He just can't see, before even getting into the evidence, he can't see, rightly I say, how it can even be said that there's an improper collateral purpose there. How is it that by bringing this application, my client can be hoping to either chill